exactly noon, and so why don't we get started? I'm Rob Glicksman. I'm the J.B. and Marie C. Shapiro Professor of Environmental Law at GW Law School. Welcome to our virtual lunch. I am here to introduce to you two most recent additions to the law school's Environmental and Energy Law program, Randy Abate and Joanna Adashek, and we will provide links to their bios and get right to it. If you have any questions that you want me to direct to either Randy or Joe, please put them in the chat. And if we have time at the end of today's program, I'll go through those questions. So I will just mention that one purpose of today's session is to introduce you to the scholarship that Randy and Joe have been engaged in and will be engaged in. And I'll note that both of them had articles in the most recent edition of the Public Land and Resources Law Review, published in June of this year. And we'll be discussing those articles with both of the authors. And so I'm going to start with a question directed toward Joe, which she will answer in connection with some PowerPoint slides that she has for you. So Joe, in rights-based climate litigation, what are the advantages and limitations of incorporating environmental right provisions into constitutions as a foundation for potential remedies?
Thank you. So I want to start with just a very, very brief overview of what environmental rights amendments are, in case some people aren't aware. In general, they are the codification of a substantive environmental right within a constitution. This can be at the national level, subnational level, international level. There's probably about 90 nations that have environmental rights amendments within their constitutions, and about 7 states in the US, depending on exactly how you define an environmental rights amendment. We're not going to read all of this. The states are Montana, Illinois, New York, Pennsylvania, Massachusetts, and Rhode Island, and they're all very different, every single one of them, and they were almost all enacted in the 1970s. And so some of the very important parts you see here are, like in Hawaii on the bottom left, each person has the right to a clean and healthful environment. So most of them start out like that and then digress and get more specific to what their own state wanted. Most recently, as of 2021, New York was almost 50 years after the rest of the states, the 7th state to enact an environmental rights amendment, and theirs was very short, 15 words. Each person shall have a right to a clean air and water and a healthful environment. Short and sweet, right? I want to start off answering this question with just an example of what ERAs can do. In Hawaii, there are multiple cases that the ERA has helped in their environmental rights amendment. In the very early on, in County of Hawaii v. Alalup homeowners, their like seminal case, the ERA created a private right of action to enforce laws relating to environmental quality. So this is the basis of how an ERA can really help states. And then these later 2 cases are kind of a story that started in 2017 and ended in 2020 and allowed environmental groups to intervene in a power purchase agreement that the Public Utility Commission was considering. And in the end, the court required the Public Utility Commission to consider transboundary greenhouse gases in determining their power purchase agreement, which is huge and very exciting. Those are my slides. I have a couple more ways that ERAs can help states specifically, and also nations, but most specifically states, in rights-based climate litigation. They can help ease standing. A lot of states have special injury requirements, like Illinois did, but in Illinois, when the ERA was enacted, the courts held that the ERA did not give people a cause of action, but eased the special injury requirement and allowed a plaintiff to sue for an injury that the public can endure as well. So helped people really gain access to courts for their environmental grievances. ERAs have also helped people enforce environmental laws. This was seen, like, as we just saw in Hawaii, and in Pennsylvania, ERA helped local government overcome standing and allowed the local government to contest the citing of a landfill permit under existing laws. So you always need an existing law. And then lastly, I think ERAs can help protect existing environmental laws, help promote the enactment of environmental laws. So in Illinois, when the ERA came around, the legislature, under the guise of really using the ERA, enacted the Illinois Environmental Protection Act and created the Pollution Control Board. So there's lots of pros. Limitations, ERAs are not the easiest thing to enact. Maryland has been trying for years and years, and there were multiple states this past year that tried. I believe Maine, Oregon, and New Mexico also tried to enact an ERA in the past year or two and did not succeed. Another limitation, if anyone is aware of ERAs, they can sometimes run into problems with being self-executing, but that could be its own webinar. So I will not touch on that a lot, and we can talk about that later if you would like.
We got a question while Joe was speaking. What does ERA stand for? And it stands for Environmental Rights Amendment to state constitutions. Randy, did you have anything to add to Joe's discussion of ERAs?
Yes, thanks. Thanks, Rob, and thanks for that helpful overview, Joe. That's it's really important to understand that ERAs have been around quite a while, and they have served some valuable, provided valuable support for environmental enforcement and litigation. For our purposes today, I want to underscore that environmental rights amendments have provided, can provide a valuable foothold for strategic climate litigation, and that's true both in the U.S. and in Canada in different ways. So I'll be talking more about that in response to some of our later questions, but I just wanted to make a note of that at the outset.
Okay, well, why don't we jump into some of your work, Randy? And you too have written about rights-based climate litigation. You've engaged in some comparative work about efforts in the US and Canada. So can you tell us what some of the obstacles are that rights-based climate litigation efforts have encountered in the two countries?
Certainly. And I'll start by saying that rights-based climate litigation shouldn't be necessary. And it's very difficult to win these cases, and it's quite time-consuming and costly. So what I mean by my point about how it shouldn't be necessary is that rights-based climate litigation really represents efforts to step in where there has been a void of legislative and/or executive action to address climate change in the more appropriate way through legislative and executive leadership. The courts should be a gap filler when legislative and initiatives and executive initiatives have taken the lead on addressing climate change. So what we essentially have in the history of rights-based litigation is almost a situation of the tail wagging the dog, that the courts have been doing the heavy lifting on trying to fashion what relief ought to be available, if at all, for climate change based harms. And that really is much more the domain of Congress and the executive. So I wanted to start there and really, with that kind of cynical lens, say that at best, rights-based climate litigation is like trying to fit a square peg in a round hole. And at its worst, it's more like trying to get blood from a stone. This has been a very challenging effort, both in the U.S. and Canada, to try to use the courts as a way to get what citizens ought to be receiving by way of protection against climate change impacts and government regulation of climate change. And it's also important to note at this stage that rights-based litigation for climate change has enjoyed a bit more success outside of North America. But not surprisingly, some of those very ambitious outcomes in the courts have struggled with the implementation phase. So in some ways, it's a bit of winning the battle but losing the war if you get a very groundbreaking decision in rights-based climate litigation, and then it just fails to be implemented. And that's what we're seeing. In one example would be in Colombia, where there was a youth-based case that was wildly successful in seeking to compel the government of Colombia to reduce deforestation in the Colombian Amazon to zero. But that mandate has yet to be implemented there. So building off of that context, I would say that when we think about obstacles, we're really talking about two primary ways in which these cases have been stymied in the courts, both in the US and Canada, and that would be standing on the one hand and jurisdiction on the other. So in standing, one way in which these cases have hit a lot of challenges is in the US, the redressability prong. So we saw this in the Juliana case, where the youth climate plaintiffs there were seeking to compel the government to engage in a climate recovery plan, a very broad-based, policy-based remedy. And the court was concerned that that was really too broad, was not redressable for the court to compel the federal government to do that. And an example of the jurisdictional concerns, both in the US and Canada, there have been examples where the court came down and said this was not justiciable to seek these rights-based remedies because this was really something for the political branches to address, being climate change, something that the legislature and or the executive should be taking the lead on. So ultimately, those have been kind of the essence of where these cases have stalled, and we can certainly talk more about that with some of the more detailed discussion later.
Joe, anything to add to Randy's discussion of the obstacles that litigants are likely to encounter or have encountered?
No, I do not.
Okay, well then we'll jump right into the next question for you. You talked about the fact that the language in the ERAs of the 7 states that have adopted them are very different. Each one is unique. And so can you describe to us whether there's a difference between a provision that describes a right to a healthful environment and one that describes a right to a healthy environment? And if there is a difference, what is its significance?
Yeah, thank you. So on the slides, you may have noticed that there were a couple different adjectives before the word environment, and you see a healthful environment, a healthy environment, a clean and healthful environment. Some scholars have said that there is a difference that can be seen in the level of protection that one word provides over the other. And as lawyers, words are very important, if I say so myself. And some say that healthful equates to an environment conducive to human health, while healthy speaks to the quality of the environment in itself. And so in Montana is a really good example of this. Their legislature held that they use clean and healthful together because they believe that that embodied anticipatory and preventative language. So they thought that using healthful alone would not be adequate enough. They actually have this really fun quote that I like. They did not use the word healthful because it would permit those who would pollute our environment to parade in some doctors who could say that if a person can walk around with 4 pounds of arsenic in his lungs or SO2 gas in his lungs and wasn't dead, then that would be a healthful environment. And so they didn't want a level of environmental health linked to people. They wanted a level of environmental health linked to the environment. So they use the terms healthful and clean, thinking that that could provide both the level of protection to protect people and also protection for the environment in itself. And this can be compared with other states. Illinois only uses healthful. They said themselves in their legislative intent that healthful describes the environment in terms of its direct effect on human life. And the Supreme Court of Illinois held that the healthful environment does not include a right to protect endangered species. And so, again, because that does not have an effect on people. So we see that in some states, and I'm sure not everywhere, the difference in the terminology you use can impact the level of environmental protection that you'll see with your ERA, your Environmental Rights Amendment.
So if you were advising somebody on how to draft a model provision, which formulation would you prefer?
So I like healthy, or I think Montana has really good protection with their covering all bases scenario. Healthful and clean seem to work well together. Seems like New York is doing something similar with clean air and pure water. I guess we'll see how that turns out. We have a little while to go before it can really be tested.
Randy, do you want to weigh in on this question?
Absolutely. Yeah, Joe's done a great job in discussing this kind of dichotomy in the language. And it's something that I think the average reader wouldn't pick up on. In common discourse, healthy and healthful seem interchangeable, but it's really important to think about this distinction as potentially dangerous if it doesn't go the right way. In that sense, the idea about our the legacy of U.S. federal environmental laws tracing back to the 1970s was really anthropocentric in how we ultimately succeeded in protecting the environment. Basically, we were committed to protect the environment because we had environmental science that was telling us that our pollution of the environment was essentially a major health and safety threat to humans. And that garnered the political will to get things done in terms of a major revolution in environmental protection. 50 years later, we're in a very different place where we're much more wise to the notion that anthropocentric lens on protecting us against climate change isn't going to work, that we're much more aware about how we are a part of that larger ecosystem that both humans and non-humans exist in this larger sense of interconnectedness. And in the fight against climate change, it's very important to build resilience in the non-human world if we care about human well-being. So I think it's essential that we embrace this healthy environment approach rather than something that is more focused on the human health and not beyond the non-human domain.
There's a question that's relevant to this discussion, so I'll throw it in now from some in the audience, and that is, what about the use of the word sustainable instead of healthy or healthful, given that the UN General Assembly has recognized a right of sustainability or linked to sustainability? Any reactions from either of you?
Yeah, I think that's a great point. And it's something that both this issue of considering human and non-human when we move forward on climate change governance, and also the notion of sustainability is something that I address in my book, Climate Change and the Voiceless, that I really think sustainable development is a potential paradigm that can guide us forward when we think about climate adaptation and resilience. And it's about taking it much more seriously. I think in the first 4 decades, if you will, of where we've been with sustainable development, it's been kind of window dressing. It's been very policy oriented and a goal to strive for, but it hasn't had any concrete legal meaning that the way it ought to. That when we think about climate change, we could have a standard based on sustainability that basically says if something is deemed to be unsustainable, it should not proceed. For instance, they proposed a massive coal mine. Ultimately, there was a case in Australia that rejected a proposal for a massive coal mine because it would take Australia outside of its carbon budget if that coal mine were permitted. So I think if we take sustainability more seriously, it could really be our legal framework for governing these decisions that have an impact on us all with respect to climate change.
Randy, let me ask you a different question. One potential impact or implication of rights creation, especially with constitutional rights, is a greater policy creation role for the judiciary. Do you think the courts are equipped to play this role? What's been the experience in judicial construction of constitutional rights-based theories in climate litigation in the US and Canada?
Yeah, I'm very torn on this issue because I'm very much of a proponent for the courts to step in when there has been this massive period of legislative inaction at the federal level. But I'm also torn on the flip side, which is those solutions, whatever they might ultimately be, that are achieved through the courts in the face of legislative and executive inaction, are often short-lived at best, if not ultimately reversed in subsequent decisions, because they are essentially pushing this boundary of what the role of the courts really is. And so I think when you put it in political question doctrine terminology, a lot of the reasoning is based on the notion of Congress and the executive are better positioned to address climate change, and the courts should not be usurping their roles. But another dimension of political question concerns with respect to the courts taking a lead on climate governance is whether they are properly equipped to produce judicially manageable standards on something as complex as climate governance. So again, the expertise rests in the legislative and executive branches and not in the courts to be the leaders on how we should govern climate change. So I think they certainly have a role to play, and it's great that the courts will step in when nothing else is happening. But it's often a false sense of victory if something good is achieved, because it's so hard to implement and it's so contrary to the way things ought to be working with leadership from the legislative and executive branches on these issues.
Joe, do you have anything to add to what Randy said?
Yeah, I have a slightly different way to answer this. That's not if the courts are equipped or not, but whether, like every other area of law, courts should be interpreting public policy. And as part of my research for my paper, I read through the arguments against enacting an ERA in Maryland for the past couple of years and listened to the live hearings that people questioned ERAs. And one of the things that came up time and time again were the court's involvement in environmental matters. And one person this really makes me laugh late at night, is one person, their scared response was that the courts will be involved. Full stop, that was the entire sentence. And that's the role of the courts. The courts are here to interpret the laws. From 200 years ago, Marbury versus Madison, is emphatically the province and duty of the judicial department to say what the law is. So it is checks and balances. Laws are made, rights are created in our constitutions, hopefully, and the judiciary interprets them. And that shouldn't be a barrier to enacting more rights for people and for the environment. So
I'd like to jump in and just give an illustration, and I agree with Joe's points there. And like I said, I'm very much of two minds on this question. The example would be the distinction between when a right is already identified to exist from outside the judiciary. So, for instance, our freedom of speech in the U.S. there it's the court is on firm ground to play its role in determining what the scope of that right is, and they've been trying to figure that out for over 230 years. I mean, just to say we have a freedom of speech, it leaves a lot, the devil's in the details, as we've seen with freedom of speech jurisprudence over the past 230 years. But when we've got a situation like what we saw in the Juliana case, and I was cheering for the plaintiffs to win on this if the court would embrace it, but a much different situation where the plaintiffs there were seeking to have the court recognize that the due process clause can be a vehicle for articulating a right to a stable climate, which was nowhere in the framers' understanding of what the due process clause meant, and over many iterations of interpreting the due process clause. Really, the closest analogy that was made by the plaintiffs in that case was the fact that same-sex marriage was ultimately found to be protected by the due process clause because marriage is so fundamental to engaging in society and fulfilling your constitutionally protected rights. It ought to be likewise recognized the way traditional marriage has been recognized. Same-sex marriage also ought to be recognized. And then taking that logic to say, well, what could be more fundamental than a right to a stable climate? So the due process clause ought to recognize that as well. And in theory, I couldn't agree more, but I think it's important to recognize the distinction between interpreting our constitutionally established freedom of speech in the First Amendment versus the court finding that the due process clause protects a right to a stable climate.
Thanks to you both. So let me direct my next question to Randy. So the nature or identity of the plaintiffs is often important in these cases. And you talk about two different categories of plaintiffs in rights-based litigation. Some of the cases are brought on behalf of youth and next generations. The Juliana and related cases are an example. But sometimes you have Indigenous plaintiffs bringing these suits. So what commonalities, Randy, do youth and Indigenous plaintiffs in the US and Canada share in seeking rights-based protections in climate litigation?
I think it's really been a common experience with these two categories of plaintiffs in a very positive and hopeful way. I mean, first of all, the reality is somewhat dire when you consider how both youth and Indigenous communities are disproportionately burdened by climate change in a very disturbing way, that they are essentially bearing the brunt of many of the impacts that climate change manifests, and are similarly ill-equipped to fully protect themselves because of their vulnerability in political power. So whether it be the marginalization of Indigenous communities to be able to have adequate protections in their place vis-a-vis the larger governance structures in the federal and state domains where there's often not adequate protection for Indigenous communities and recognition of the rights that they have in that three governance system, if you will. And likewise, youth plaintiffs are not equipped to vote if we've got them of that age, below 18. And so you've got a situation where they're essentially decisions are being made without their sufficient input and without their ability to influence those decisions that have a disproportionate burden on them in terms of physical impacts of climate change. So they're seeing how their day-to-day lives are being compromised by climate change impacts. But in recent cases, there's also been a commonality in terms of the mental health impacts that climate change imposes on both youth and Indigenous plaintiffs, that sense of a lost hope for a future that's dissolving before their eyes. So those kinds of allegations have been partnering in these cases, both in the US and in Canada, where you see an alignment of youth and Indigenous communities and arguments in the same case, and we've seen that in Juliana and LaRose, the Canadian counterpart to Juliana, and we're seeing it at the sub-federal cases in both Montana v. Held and Mather in Canada. So we're certainly seeing an alignment that is positive. But it's still very troubling that that in order to get that recognition, the youth and Indigenous plaintiffs have to use this nearly impossible road to go down rights-based climate litigation claims that are very time-consuming, very costly, and a long shot at best in terms of succeeding, while these disproportionately burdensome impacts are affecting their day-to-day lives.
My next question is one that I think each of you will probably want to chime in on, but I'll start with Randy. There's been a huge battle in the US over which level of courts get to resolve the issues in these kinds of cases. And we've seen cases in many of the federal circuits in which the question is whether or not defendants in some of these rights-based cases are able to remove cases originally filed in state courts into federal courts. So can you tell us what differences exist in seeking relief at the national versus subnational levels in youth and Indigenous climate litigation in the US and Canada? Why is there so much focus and activity on getting it into the court of choice on the part of the plaintiffs and defendants?
Yeah, there are major strategic concerns here that weren't apparent until this line of cases really started about 15 or so years ago now. So there's an initial barrier that plaintiffs now navigate around, and it's known as federal displacement. And this came up in the American Electric Power case versus Connecticut, and that reached the Supreme Court. And ultimately, the logic behind federal displacement says that there was an effort to use federal common law coupled with public nuisance as a way for plaintiffs in that case, who were states, seeking to compel major power companies to reduce their carbon emissions by 25%, to essentially seek to compel the courts to have that those emissions in that power sector reduced by 25%. And so what the court ultimately concluded was, we have the Clean Air Act. If you're seeking to have regulation that pertains to emissions from these plants, that your creative effort to do an end run around the Clean Air Act is inappropriate. We have the Clean Air Act, and the remedies must flow through the Clean Air Act. So that became known as federal displacement. So with that doctrine in place, we're now seeing more recent cases that are ultimately trying to get climate litigation, whether it be rights-based or otherwise, to be heard in state court, because there's a better chance of those cases getting to trial and avoiding that federal displacement barrier. So we are seeing that in a couple of different lines of cases. One is happening in the Juliana line of cases that is now in state court in Montana. And I'll talk more about how that's coupling rights-based protections with a new theory there. And then there's another line of cases where cities and states and counties are suing fossil fuel defendants for contribution to their climate adaptation costs. And in those cases, the defendants sought to have the case removed to federal court so it could benefit from that federal displacement rationale. And ultimately, the cases, 5 circuits now have agreed that those cases should be heard in state court, and they would be proceeding to trial in state court, which is a massive victory for the plaintiffs there, because even if they don't win in state court at trial, just the discovery process of airing what is known from the defendant's side in terms of what they knew about the climate science, when they knew it, and what they did with that information with respect to the public's right to know, that's going to be very positive even without a victory at trial.
Joe, do you have any response here?
I'll mostly second what Randy said. It's a harder question. Obviously, there isn't an environmental rights amendment at the national level. We only have seen subnational level. Sorry, there are just not the US national level. There are many nations, again, with environmental rights amendments. it's hard to compare other nations' ERAs and their litigation with state litigation, which is again on a smaller level. So I think what will be really helpful in the future is to see how these state litigations turn out, like the Montana case, which is using its ERA, hopefully, to go further than Juliana was able to go at the US national level. And hopefully we'll see that in other states as well.
And I want to follow up on that, kind of how we got to where we are in the most recent cases, both in the US and Canada, with these proceeding at the subnational level. So ultimately what we saw both in the US and Canada was an initial effort to compel the federal government in each country to essentially do something they chose not to do to address climate change. Whether it had been addressed in a limited way and needed to be more ambitious, or whether it hadn't been done at all, those cases against the federal government were ultimately deemed to be too broad and policy-based, and ultimately they were tied to a rights-based entitlement, but there wasn't a sufficient connection between that broad effort to compel the federal government to engage in something that was within their discretion to do or not do. And so what we saw was these cases getting dismissed on justiciability grounds, and then there was a retooling of trying to connect a rights-based theory protection to a specific law that was enacted that did something and didn't do it well enough, or did something harmful to the plaintiff's interests. And now we're seeing it in both countries, the Mather case, which is based in Ontario, a much narrower scope, a type of claim that's being made compared to the previous ones, which were, broad-based federal government claims. So there's a specific climate change regulation law in Ontario, and ultimately the challenge is being made to that being insufficiently protective of citizens in Ontario, and they're connecting it to a rights-based claim in the Canadian Charter, including claims under sections 7 and 15 of the Canadian Charter, which refer to protection of life, liberty, and security of the person in section 7, and right to equality in section 15, and ultimately connecting that failure to do something adequately under the law, the specific law, as a breach of those rights-based protections. And we're seeing the same thing in the US. So in Held v. Montana, we're seeing the rights-based provision that Joe alluded to as the foundation of the breach of rights, and it's being tied to a particular law in Montana that's enabling the advancement of fossil fuel as a primary foundation of the energy mix for Montana, and how that is essentially breaching the rights that exist in that ERA in Montana. So we're seeing very similar approaches in both instances. And the third piece that's most significant here is that it's declaratory relief now, both in the US and Canada, that is ultimately proceeding to trial. The previous cases were largely injunctive, and we saw another line of cases that was seeking damages, but now these cases have been refined to seeking only declaratory relief. So essentially there's a right and it's been infringed. And then, the question becomes, okay, but what does that get you? Ultimately, if you win, the government isn't required to do or refrain from doing anything. It's not, there's no mandate to pay damages, but that's how slow the progression is in this line of cases, that you first have to establish that there's a right and it's been infringed, and that provides a foothold for subsequent efforts under different laws.
It's interesting that you mentioned that the plaintiffs are seeking declaratory relief in some of these cases. Initially, injunctive relief was sought, and it seemed pretty clear that the courts were uncomfortable providing injunctive relief, either because they thought it was overstepping their bounds, or because they didn't think it was enforceable. And so in some of these cases, like some of the ones brought by cities, they shifted to damage claims. I read an article this morning that made the argument that damage claims should never be recognized, never, in a public nuisance action. What do you think of that argument?
I'm a little troubled by that argument because essentially these cases that are being brought on that line of cases that are suing the fossil fuel defendants for contributing to the cost of these climate adaptation expenses that these cities and states are facing. I mean, this is ultimately the essence of what public nuisance can provide. I mean, we certainly got precedent that both injunctive relief and damages can be available, and in this case, injunctive relief certainly wouldn't be happening anytime soon. We're not going to stop dead in its tracks our reliance on fossil fuels in our energy mix. As much as that would be nice, it's not going to happen. So damages is really the only appropriate relief here, and absolutely, if the plaintiffs prevail in their case, it will be well demonstrated that there is a significant contribution of these defendants to these costs, and it's a very direct link as far as their legal responsibility to contribute to those costs.
We've got a bunch of good questions in the chat and Q&A functions, but before I turn to them, I just want to ask both of you whether there's anything about your recent work on rights-based climate litigation that I've neglected to ask you about that you'd like to dig into before we go into the questions.
I mean, personally, I love talking about environmental rights amendments, and I can talk about standing and self-executing and all those fun nitty-gritties for a while, and we have 20 minutes. I also did note Bill's comment in the chat, and I was going to respond to it, but we can respond at the end if necessary. So I think we can go into the Q&A unless Randy has something he wants to add.
Yeah, there's one thing that I will add, and I would just say on the flip side, as much as I've been concerned about how difficult and slow rights-based litigation has been, and how difficult it is to achieve victories, and even when you secure victories, sometimes it's winning the battle and losing the war. It's important to recognize that this battle is so important to continue to fight, ultimately because if you're not getting progress in the courts, you are getting progress in the court of public opinion. And that has been so valuable in the US and Canada and globally for the climate justice movement. It's really helping push the needle for legislative action, whether it be at the federal or sub-federal levels, and ultimately influencing discussions that happen at the COP meetings for climate governance. So there's this groundswell of support for this kind of action to really move forward, and I think we're really at a critical moment in history that there could literally be a revolution in this direction sometime in the next 5 to 10 years, based on what we know of the climate science, based on the demands that we're hearing from the marginalized communities and what they're experiencing, and just by virtue of listening to the news any day of the week and seeing how climate change is manifesting in these climate justice tragedies around the world. It's not something that's in the distant future. We're living it, and that was one of the biggest roadblocks to effective action on climate, is that we weren't seeing it quite as readily as some of the other environmental problems in the US in particular. When you think about, the smog in LA that ultimately motivated the Clean Air Act, or the Cuyahoga River catching fire as a motivator for the Clean Water Act, and of course Love Canal for our hazardous waste response. We didn't have anything quite so concrete with climate change, and so it was always easy to put it off. But now we're living that tragedy in our country and around the world, and I think it's really important that rights-based litigation continue to build that awareness about the urgency of the situation from a human rights perspective.
Thanks for that. So I will turn to some of the questions. And the first question I want to pose to you is one from somebody that I'll actually identify because it's somebody that Randy and I both know quite well. It's Jim May. And Jim asks whether there is quantitative evidence that subnational environmental rights amendments in the US actually improve environmental performance in the 7 states that have those amendments?
Quantitative evidence is a very interesting term for me. I personally do not have quantitative evidence. Before and afters are really interesting, and every state, of course, is different because the language in their ERAs are different. It does seem that in many of the states where ERAs have been enacted, there is this general, when they are used in litigation, because of course they have to be used in litigation to impact the case, they have this effect of bolstering the other environmental laws at use. And so in many of the states, that is one, if not the main function of an ERA. And so if bolstering existing litigation, which may have existed before or may exist after because of an ERA, which has been shown in many states, then I think there is definitely something that says that ERAs, if not help create enacting more environmental laws, do bolster previously existing laws. And that is, of course, better than nothing. They don't hurt, for sure. So sorry for that sub-adequate answer.
Okay, let me ask another question that relates.
Actually, Rob, could I jump in a bit?
Sure, go ahead, Randy, sorry.
Yeah, Jim's question is absolutely the right question. And in fact, he's very well known for generating really valuable quantitative data on environmental enforcement. And I'm putting in the chat a paper he wrote on citizen suits, and he's gathered a lot of really valuable information about measuring the effectiveness of citizen suits. And ironically, I also would encourage Jim to take a look at Rob's recent article about some of the limitations of what citizen suits are able to achieve under environmental laws, which is another important reality as we think about strategic environmental litigation. But yeah, I really think that that will hopefully be Jim's next article, because I'm not aware of any quantitative data on the effectiveness of ERAs either. I mean, it's certainly been somewhat underutilized, given how ambitious they are in their language. I haven't seen nearly the degree of case law on these provisions as I would have expected, and I'm hoping that the connection to rights-based litigation will draw more attention to them and dive in a bit more about how they can be used for optimal benefit.
Our next question asks, how can one balance in applying environmental rights amendments, the conflict between the need for energy alternatives, cleaner energy alternatives, and the effects these alternatives sometimes can have on the health of natural environments? Things like solar farms destroying desert ecosystems, or deep ocean mining for lithium batteries that disturb those remote habitats. Any ideas about those points?
I think that's an interesting question. I think any like law or right in itself involves a balancing game. It would fully depend on the case and what other laws were used in the litigation. So if somebody is contesting the siting of a solar farm, there again has to be another law for them, because the ERA does not provide a cause of action in most states. And so there would need to be another law that says somehow limits where you can cite, or the area you can cite, or how you cite solar farms, or whatever the energy is. However, with that, the amendment would probably have the courts look at both sides of the case. So I do think it would be an interesting balancing case. When I was in the environmental law clinic at Maryland, I read through every case that was on Lexis that cited the environmental rights amendment in 4 of the 6 states that had them at the time, not New York. And I did not see anyone using an ERA to fight clean energy. So that would be really interesting.
Randy, any thoughts on that one?
Yeah, I mean, I certainly don't have any concrete answer for that. It's a great question, and I think it just it really reinforces a lot of what's being discussed about the just transition and how complex and how important that is to be thinking on a multi-level basis about a lot of these issues. So one of the challenges of rights-based litigation is that it often is addressing a situation exclusively through a climate change lens. And in many ways, climate and energy issues need to be synthesized these days, because ultimately they are synergistic, compatible ways of thinking about a better future for humans and the environment. So I think that's there's again a danger of winning the battle but losing the war if you win that strategic rights-based climate case, but ultimately the devil's in the details make a mess of the energy transition. There has to be a broader based thinking about the way these issues intersect.
We've got a question that's directed to Randy in particular, and you may have already begun to address this question, Randy, in your comments after the questions that I directed to you. The question is this: many of the U.S. state court cases were originally filed 2011 and mostly were thrown out, but the field of climate science has grown significantly since then. So is there any hope for reviving any of these cases given the advances in climate science that have taken place?
Yes, that's a really important question to be asking in 2022, because when I think back to the Kivalina case that was ultimately unsuccessful in the Ninth Circuit, a big concern that the court had back then was looking at that coastal erosion in northern Alaska and saying essentially that the defendant's emissions, there would be no way to causally connect the defendant's emissions to that particular coastal erosion in Alaska. I mean, the science just didn't support it, and that was back in 2007 maybe. And 2007 to 2010, maybe, when that case was progressing. So I think now in 2022, there's been remarkable progress on the field of climate attribution science, and it wouldn't be so much of a slam dunk to say there isn't an opportunity to have a tighter nexus that might survive, certainly on standing grounds anyway, because it's merely a fairly traceable standard for causation at the standing stage. And it's a mere 15 years later, and yet climate attribution science has advanced so significantly that I'm not convinced the court would have reached the same decision in that case with the benefit of today's climate science. So that is really, that and what we see from the IPCC reports is ultimately an incredible boost to climate litigation plaintiffs on many levels. The science supports the claims, and the science is getting stronger by the day.
Here's a question that I think Joe could probably chime in on. The question is this: in U.S. states with an explicit right to a healthy environment, are there states where the contours of that right have been well developed by courts in a non-climate context, as in environmental rights precedent? Or are applications in the scope of these ERAs largely uncharted in the litigation context?
So if I'm understanding the question correctly, the majority of cases involving ERAs in states with ERAs are not actually about climate litigation. Climate litigation has been a fairly recent phenomenon to include ERAs with. The cases that I shared with Hawaii in the PowerPoint slides were some of the more pertinent cases. A lot of them have to do with water issues and siting and landfills and hazardous waste. And there is a lot of case law in some states. Pennsylvania has a long history of their ERA, both good and bad. Again, if we wanted to touch on self-executing, that would be a long story. But like states like Hawaii, they saw such little litigation with involving their ERA that they actually enacted a law to give people using the ERA and environmental laws the attorney's fees if for cases in certain circumstances, because there were so many after the fact permits that were being given out, and the state of Hawaii wanted people to use the ERA to fight problems that either the government couldn't handle or wasn't equipped to handle. And most of these cases probably aren't in the climate context, but as we're seeing in Montana and all these other states and Rhode Island recently with suing a bunch of oil and gas companies for their pollution, the case law will grow immensely with the climate context, but it has already been developed largely with other contexts.
Here's a question that either one of you might be prepared to answer. It's again from Jim May, and he's asking whether you think the recent report from the Commission on Human Rights for carbon majors is or can be relevant to rights-based litigation in the US, if at all. Would it affect the kinds of causes of action that might succeed, the ability of plaintiffs to demonstrate standing, the scope of discovery, the nature of motions practice, any of those things?
I think the symbolic relevance of that case is enormous. I mean, I think it's done a lot of the groundwork for claims in the US context. I think just making the case that this is a attainable kind of connection between what the fossil fuel industry is doing in its practices and ultimately making connections to climate to human rights-based impacts in any kind of legal forum is incredibly valuable for a foothold for these other claims. There's a lot of the groundwork that's already been done that can be duplicated in framing the claims in a US context or Canadian context. And I think that again, this notion of building that sense of advocacy support, that it's possible, because when you think about ultimately what the fossil fuel industry wants is predictability. It wants to be able to plan for a reliable, profitable bottom line. And when there is pressure and the likelihood of success in these claims for multi-million-dollar judgments, ultimately the way we're going to get ambitious regulation on climate change most effectively is for the fossil fuel industry to approach Congress and say, please regulate us in a reliable way, because we're not going to be able to live with the threat of these multi-million-dollar judgments for very long if we want to stay in business. So any success anywhere in the world is an opportunity for gains in US or Canadian courts.
Maybe we have time for one more question and quick answer, and it relates to the relationship between environmental rights amendments and achieving environmental justice. And the question in particular asked whether ERAs can be used to ensure environmental justice in Africa.
I think that's a great question. And I second that Professor May pointed the person who asked the question to a scholar who is definitely much more adept than I to answer this. But I have seen I've only studied states in the US, but within that, there have been, with existing laws, ERA has been a nice little gap filler when laws have not touched on certain environmental subjects. And this has been seen especially with cumulative impacts. And so ERAs can potentially help. Again, it depends on the language and the court interpreting the Environmental Rights Amendment, but could help with cumulative impacts and people in environmental justice communities who see the impacts of pollution more than others. But again, please reach out to that scholar who definitely knows much more on the subject than I do.
That's Melanie Murcutt.
Mhm.
Randy, any final comment?
Not on that point. I just want to thank everyone who joined us today and encourage everyone to remain in touch on these issues. Happy to continue the conversation. And also please keep an eye out for our future events. This is going to be an ongoing theme where we're looking to build out the social justice dimensions of environmental and energy governance issues in our program. So we hope to see you at future events, and please stay in touch with us in the meantime.
Let me just echo. Go ahead, Joe.
I'm posting our events page in the chat for anybody who wants to follow along with us. And you can also follow us on our social media accounts, which I will also post in the chat.
Let me echo Randy's thanks to those who took the time to attend today. I know I found this discussion fascinating, and I'm sure it could go on for quite a bit of time, but we're out of time. And so do contact us if you've got further thoughts, questions, ideas. And we look forward to seeing you at future GW Law, Environmental and Energy Law events. Take care, everyone.